Foreign companies contemplating to sell their products or services in France may envisage a number of different legal frames and means such as agencies agreement, distribution agreement, franchise agreement. According to international lex mercatoria rules, the law applicable to a distribution agreement is left to the party. If the agreement does not provide law and jurisdiction, the place and territory, forum lex, where the agreement is carried out, will determine the law and jurisdiction. The French law states that the definition of a distributor is an independent entity which buys goods, services and resells them to third parties upon trading agreed conditions. A distributor may be appointed for a particular territory either on an exclusive or non-exclusive basis. There is generally no compensation for the loss of customer bases at the expiry of termination of a distribution agreement, although of late case law has envisaged compensation for major investments realized by the distributor on behalf of the manufacturer. The French law illustrates that there is no statutory notice period, although many agreements tend to have a 3 months, 6 months notice period. According to the French laws, the role of a commercial agent who does not buy and sell the goods or services, but only promote them toward a client basis on behalf of the manufacturer, is strictly defined by legal provisions in the commercial codes, which are generally in favor of the agent, especially upon termination of the agreement. The commercial agent must be registered as such upon a special statutory list held by the registrar of the local commercial court. The French laws makes difficult to dismiss a commercial agent in France, other than in a picture of serious breach or misconduct. It is virtually impossible to remove a commercial agent without paying significant compensation. In any event, it will generally be necessary to pay compensation for the loss of customer bases upon the expiry of termination. Such compensation can raise 2 years' commissions in some occurrence cases. In French laws, the concept of franchise agreement is particularly well integrated into the world of French business and commerce, and there are numerous legal frameworks possibility on the offer. It is self-evidently vital to ensure that the know-how offered within the scope of a franchise is real and is likely of being transmitted to a third party. The law called Loi du Treil provides a huge list of mandatory obligations upon the master franchisor. To this end, and to ensure that all parties are fully aware of the purposes, commitments, terms and conditions of a particular franchise business, the French laws require that a pre-agreement document must be drafted and executed thereby.